appeal in the matter of Okafor and the Secretary of State for the Home Department.
Yes.
Good morning, my lords. I appear on behalf of the appellant, the Secretary of State for the Home Department. My learned friend, Mr. Jafferty, appears on behalf of the respondent, Mr. Okafor. I'm standing in for counsel who drafted the skeleton argument, who unfortunately can't be here due to an emergency. As this is a second appeal, there can be some confusion in references to appellant and respondent, and for those reasons in my submissions this morning, I intend simply to refer to the Home Secretary and Mr. Okafor.
Thank you.
In terms of housekeeping, my lords, very briefly, there should be in front of you a core bundle of 19 tabs, a supplementary bundle of 11 tabs, an authorities bundle of 12 tabs, and the Secretary of State's replacement skeleton argument dated the 27th of November, 2023.
Pretty sure I've got that. 27th November. Yes.
I'm grateful, my lord. My lords, the scope of this appeal is narrow, and the arguments are focused, with a number of the key principles agreed by the parties. The only ground of appeal is set out in tab 2 of the core bundle. If I may quickly read it to the court, no need to turn it up. It's that the upper tribunal erred in law in failing to consider the cumulative effect of the respondent's behaviour and whether his drug offending, considered in conjunction with his repeat and recent deception, fell within the scope of the Bouchereau exception.
When you come to it, will you explain to us how paragraphs 29 and following of your skeleton fall within that?
My lord, perhaps I should deal with that now. Very briefly, I accept your lordship's point that in this appeal, my two submissions were going to be that the judge erred in approach in dealing with matters separately, and separately, a second submission that the judge failed to take into account the length of Mr. Okafor's sentence. Now, I understand my lordship's point to be that that second submission doesn't clearly fall within the ground.
Not at all. Not clearly, not at all.
My lord, I would say, I take your lordship's point. In those circumstances, my lord, in order to advance that argument, I would seek the court's permission to add a second ground of appeal in relation to that specific point. My lord, in making that application, I should say this, that the point has been quite clearly developed in the skeleton argument, so the respondent has been on notice of that point. The point is also not far detached from the primary point, or as my lordship points out, the only ground of appeal, which is the approach to assessing conduct. And part of that approach is taking into account the length of a sentence.
So can you tell us the precise wording that you would propose to add as a second ground, please?
My lord, I would say that the second ground would then be that the upper tribunal erred in law in failing to take into account Mr. Okafor's length of sentence in assessing his behaviour. And that ground, my lord, would relate to the paragraphs that my Lord Justice Stuart-Smith has identified in the skeleton argument.
So, Andrew, yeah. So you make that application now?
I do, my lord.
Yes. Okay, thank you. Is there
My
anything
lord,
else?
all I would say is perhaps if it would assist the court, and because I think there is ample time and I won't be long in my submissions, it might be that I make the submissions under that ground before the court decides whether or not to.
No, because we've read your skeleton, so I don't think we need that. Thank you
I'm grateful,
very much.
Lord.
Mr. Jafferty, what would you say in response?
My lord, the respondent opposes the application. Of course, this is a second appeal, and therefore one only gets permission at the Court of Appeal if it raises an important point of principle or there's another compelling reason for permission to be granted. It's far too late to make that application. I accept my learned friend's point that it's been set out in the skeleton arguments, but the grant of permission was very specific, and it would not be appropriate at this late stage to go beyond the scope of the grant of permission, which clearly relates to the scope of the Bouchereau exception, and the cumulative issue is clearly relevant to the scope. Whether the upper tribunal took proper account of the length of sentence is not a point of principle. It's a point of assessing the upper tribunal's approach on the facts.
Yes. Thank you very much. Do you want to say anything in reply?
Briefly, my lord, I see what my learned friend says. However, how a court approaches the length of a sentence is a fundamentally important assessment, which does in and of itself raise an important point of principle. Because we have on the one hand the fact that the legislation says that the length of its sentence and a conviction itself is not in and of itself determinative of anything. But we also have the legislation telling us that the length of sentence must be taken into account.
Yes, thank you. We're going to rise for 2 minutes.
I'm grateful.
Rise, if able. I would like to inform the court that the recording is still going on, so if there's any personal conversations. Court rise, if able.
Mr. Lewis, thank you. We'll deal with this more fully in our judgments when they are handed down, but we refuse the application. In very brief summary, it's too late, and in our view, in any event, it is unarguable. So thank you.
I'm grateful, my lord. My lords, this appeal is concerned with the approach that a decision maker should take when making an assessment. The Home Secretary's case is that all relevant conduct should be assessed as a whole, cumulatively. As we shall see when going through the authorities and the legislation, there is nothing which indicates otherwise. The Home Secretary therefore submits that Upper Tribunal Judge Grubb erred when applying the test sequentially, first looking at Mr. Okafor's drug conviction, and then separately looking at his much later immigration deception. Permission was granted by Lord Justice Bean on the 11th of April on the basis that this case raises an important point of principle as to the scope of the Bouchereau exception, and it has a real prospect of success. Subject to the court's direction, the structure of my submissions this morning will be as follows. I intend to give the barest of outline of the facts, taking the court to a few documents. I then propose to take the court briefly through the statutory framework and the key authorities, so as to understand what the exception is. I then wish to turn to the judgment itself of Upper Tribunal Judge Grubb, and occasionally make reference to the first-tier tribunal decision. And in going through Upper Tribunal Judge's judgment, I was going to make two key submissions. I'm now only going to deal with one, which is simply that he dealt with the criminal conduct and deception separately, rather than together. I'll finally make a few comments on the respondent's notice, but be brief on that point.
Thank you.
Turning to the facts in outline, which are set out in paragraph 5 of the replacement skeleton argument onwards. Mr. Okafor was born in Nigeria. He moved to the United States of America in around 1990. On the 12th of December 1992, he was arrested and charged with conspiracy to possess with intent to distribute and/or import heroin. He was later sentenced to 350 months imprisonment. He was released in January 2019 and returned to Nigeria in May 2019. In that month, he married a Swedish national who had been living in this country since 2014. In late 2019, Mr. Okafor made 2 applications for a visa to visit his wife. And in both of those applications, he lied about having no previous convictions in any country. My lords, it might be helpful, very briefly, just to look at what he said in those applications so the court has it clearly in mind. And that is in the supplementary bundle at tab 2, page 58. We see that that is the visa application form dated the 31st of October 2019. And if we turn over a few pages to page 64 of the bundle,
Yes.
we see convictions and other penalties. And in the left-hand column, the question is asked, at any time have you ever had any of the following in the United Kingdom or in another country? A criminal conviction. And his response is, no, I have never had any of these.
Yes.
My lords, the further applications are in very similar terms, and the application forms are set out similarly. If it's of assistance, I can just give you the page reference.
Okay.
The page reference for the 24th of December 2019 is page 66 in the same tab. And the dishonest answer is at page 73. And then Mr. Okafor made an application for a residence permit, which he received. And in that application, he also lied. That application was made on the 15th of February 2020, and that's at page 76 of the same tab. That's tab 2, the supplementary bundle. And the dishonest answer is midway down page 80.
Yes. Thank you.
As I've indicated...
These are electronic, are they?
Yes, I understand them to be electronic, and then when they print it out, they appear this way. Returning to the chronology, on the 30th of July 2020, Mr. Okafor was granted his EU settlement scheme family permit, valid until...
Or are they drop-down menus that produce these answers? I mean, no, I have never had any of these. Is that one of the drop-down menus options that you select?
My lord, I can take instructions. I don't know.
I'm just looking at some of the other answers, such as other history, in either peace or wartime, have you ever been involved in or suspected of involvement in war crimes, crimes against humanity or genocide? And the answer is no, I have read all the information about war crimes, including the guidance. And that seems to have been a little odd that somebody would make that response unless it was given to them on a drop-down menu.
Yes, my lord. My lord, I look to my learned friend who might know better than I do.
My lord, my understanding is that it is a drop-down menu option. I think that's why you have the same answer in both applications, rather than him saying, no, I have never had any of these.
Yeah, I mean, obviously, that's the statement he makes by selecting the drop-down
Yes.
menu. But
Yes.
okay, just to be clear. Yeah.
I'm grateful to my learned friend for that indication. His permit, which we don't need to look at, but just for the court's note, is at page 31 of that tab 2 of the supplementary bundle. On the 16th of September 2020, Mr. Okafor arrived at Heathrow Airport, and he was first refused admission, And that decision, which is the original decision that was appealed, is in the core bundle at tab 17. The court need not read it in full. I just indicate that the key line is perhaps halfway down the first paragraph, which says, you hold an EU Settlements Family Scheme Permit for this purpose, which was issued by the Home Office on the 30th of July 2020. However, I'm satisfied that refusal of admission is justified on serious grounds of public policy. This is because you've sought to conceal your criminal conviction in the United States of America. At the same time and at the same point, the leave that he had under that permit was cancelled. Now, this was
the refusal of admission was because of concealing the conviction rather than the conviction itself.
It appears from the way that it's drafted, my lord, yes, that is the thrust of this decision.
Thank you.
The decision to cancel the permit, effectively, was originally made on the same date. And we see that by turning back a tab to tab 16. And much of this decision is understandably cut and pasted. The second paragraph indicates that the decision is justified under the immigration rules on the grounds of public policy, public security, or public health.
Sorry, I'm struggling to find where you're at.
I apologise.
Sorry, no, it's me. Go on.
It's tab 16, and then the notice of cancellation of leave to enter document. It says to Henry, and then the first paragraph, the second paragraph says, however, I'm satisfied that the cancellation of your current leave is justified.
Yeah, sorry, I was in the wrong bundle. Sorry.
My lords, that was issued, I understand, on the wrong form, and it was later reissued, effectively the same decision on the correct form. It was reissued on the 22nd of September 2020, and very briefly, that's at page 18.
Tab 18.
Tab 18, sorry. On the 21st of May 2021, First-tier Tribunal Judge Moylan allowed Mr. Okafor's appeal against those decisions. And later on in my submission, I'll turn to his decision briefly. On the 28th of February 2022, Upper Tribunal Judge Grubb set aside Judge Moylan's decision on the basis that he had not considered the Bouchereau exception. That judgment is in tab 9 of the core bundle. Finally, on the 14th of July 2022, Upper Tribunal Judge Grubb handed down a decision remaking Judge Moylan's decision in Mr. Okafor's favour. That is the decision that is being appealed against at tab 8. I will go to it in some detail. I should note that the two judgments, the one to set aside and the one actually making the decision under appeal, are very similar because the judge quite sensibly cut and pasted some of the common parts between them. So they look, and for that reason, there's no real reason for me to make any reference to the set-aside decision.
Except for the last two paragraphs, where he preserves the finding.
Yes. Yes, my lord, I accept that. My lords, I won't take much time on this, but I do think it might be helpful to now go to the regulations, just to explain them,
Yes.
as they're not very long. They're dealt with in the replacement skeleton argument at paragraph 11, but I think it most helpful to turn to the authorities bundle and start at tab 1 of the authorities bundle.
Yes.
I should say at the outset that these regulations have been revoked in their entirety as of the 31st of December 2020. And that was by the Immigration and Social Security Coordination EU Withdrawal Act 2020. There is reference to this in footnote 2 of the replacement skeleton argument. But in that footnote, it's noted that there are transitional provisions which preserve appeals in respect of decisions that have been made before.
Yes.
I don't have any firm instructions, but certainly in the application to permission to appeal to this court, it's indicated that there are a number of these appeals that will still be determined.
But it's common ground that the old regime is preserved. For our purposes, all we need to know is that the EEA regulations regime is preserved.
Yes, for the purposes of these appeals. Yes, and I think that is common ground.
Yep.
Great, my lord. My lord, if we start with Regulation 23, tab 1 of the authorities bundle.
Do you happen to have is it preserved in the, it's going to be somewhere in the regulations, isn't it, or in the Act that it's preserved in respect of existing?
My lord, it's actually preserved in a statutory instrument.
Right, what is it?
I think it's, let me check it. I've got it in front of me, but I'll tell you what it is and then see if it's referred to in the Scala.
Doesn't matter, just give the name
Sure.
and number.
It's the Immigration and Social Security Coordination EU Withdrawal Act 2020, open brackets, consequential, comma, saving, comma, transitional and transitory provisions, close brackets, open brackets, EU exit regulations, open brackets, SI 2020/1309.
2020-1309. Okay. It's probably one of the requirements of the EU withdrawal agreement.
It is, my lord, and I think in the EU withdrawal agreement at Article 20, these kind of rights are dealt with.
Yeah.
My lord, starting with Regulation 23,
Yes.
exclusion and removal from the United Kingdom, I'm just going to take the court to the key passages. 23.1 provides a person is not entitled to be admitted to the United Kingdom by virtue of Regulation 11 if a refusal to admit that person is justified on the grounds of public policy, public security, or public health, in accordance with Regulation 27. Skipping ahead, Regulation 23.5 provides that if the Home Secretary considers that the exclusion of an EEA national or the family member of an EEA national is justified on the grounds of public policy, public security, or public health in accordance with Regulation 27, the Secretary of State may make an order prohibiting that person from entering the United Kingdom.
Yes.
Subparagraph 6 provides that subject to paragraph 7 and 8, an EU national who has entered the United Kingdom or family member may be removed if B, the Secretary of State has decided that the person's removal was justified on the grounds of public policy, public security, or public health in accordance with Regulation 27. We then turn over the page to Regulation 27 itself. 27.1 provides that a relevant decision means an EEA decision taken on the grounds of public policy, public security, or public health. Then importantly, Regulation 27.5 provides that public policy and public security requirements of the United Kingdom include restricting rights otherwise conferred by these regulations in order to protect the fundamental interests of society. And where a relevant decision is taken on the grounds of public policy or public security, it must also be taken in accordance with the following principles, of which 6 are set out.
Yes. And the important context is these are regulations that apply a derogation from the normal principles that apply to EEA nationals or their family members.
Yes, my lord. So where these regulations are different from the law that would pertain to a national from any other non-EEA country, obviously there's the important right, or was the important right, of freedom of movement.
Exactly.
And this is a derogation from it.
Exactly.
So special considerations apply.
Exactly.
And it is more difficult, of course, to remove an EEA citizen than it would be a citizen, say, from South Africa. I won't read out the 6 factors, but the most important one is C. The personal conduct of the person must represent a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society, taking into account past conduct of the person, and that threat does not need to be imminent.
Yes, and the repeated use of the word fundamental shows the threshold, or the fundamental interests. It's a strong word.
It is a strong word, my lord. And my lord, as far as I'm aware, the authorities don't really focus upon it, partly because, as we'll see when turning to Schedule 1 in a moment, First, it's accepted that what those interests are varies from country to country.
Yes.
So there's some discretion. And second, because in that schedule, as we'll see, some of those fundamental interests are actually set out.
Thank you.
And the upper tribunal judge expressly accepted that subparagraphs A and G were engaged for the drug offending and for the lying on immigration appeal.
He did, my lord. So, as far as I'm aware, that's not an issue.
That's not an issue, as I understand it.
No.
So you're taking us to Schedule 1, Paragraph 7.
Just before I do, if we turn over the page, I'll just see how we get there. Paragraph 8, subparagraph 8, says a court or tribunal considering whether the requirements of this regulation are met must in particular have regard to the considerations contained in Schedule 1.
Yes.
And then over the page at Schedule 1, paragraph 1 makes the point I've just made in response to my lordship's question, that member states are given some discretion in this matter.
Yes.
And then the further paragraphs apply to the application of paragraph 1, and it gives us some guidance. And there are a couple that are key here. Being paragraph 3, and this really is fundamental. Where an EEA national or family member of an EEA national has received a custodial sentence or is a persistent offender, the longer the sentence or the more numerous the convictions, the greater the likelihood that the individual's continued presence in the United Kingdom represents a genuine presence and sufficiently serious threat affecting the fundamental interests of society.
Yes.
And then paragraph 5 works the opposite way, in saying that if the person has positive evidence in their favour, that must be taken into account. Paragraph 6b talks about public policy minimising fraudulently obtaining or attempting to obtain or assisting another to obtain or attempt to obtain a right to reside under the regulations. And then in response to my lordship's earlier question, at paragraph 7, we've given guidance on what the fundamental interests in society are. Most of these are fairly obvious. The ones that are relevant are 7a, which is preventing unlawful immigration or abuse of immigration laws. And F, excluding or removing an EEA national with a conviction. I should note just in passing...
Hold on. You concentrate on F, isn't G more directly relevant? Offences with a wider societal harm, such as offences related to the misuse of drugs.
Yes, my lord. The reason I haven't stressed G is because there is a factual finding that Mr. Okafor does not have a propensity to cause such harm in relation to drug offending and cause wider societal harm.
That doesn't make G irrelevant, though, does it?
No. My lordship, I accept that G is relevant.
Okay. So F and G.
Yes, A, F, and G. My lords, I note simply in passing that it is agreed between the parties on the basis of the authorities that the burden of proof rests on my client, the Home Secretary. And that was established in an upper tribunal decision called Arans, which we need not turn to, but I note is at tab 9 of the authorities bundle. Turning very briefly then to the authorities to set out what the scope of the exception is, and taking your lordships just to a few paragraphs in each of them. The starting point must of course be the decision in Bouchereau, if I'm pronouncing it correctly, itself, which is at tab 4 of the authorities bundle. And this is a decision of the European Court of Justice made back in 1977.
Can I just ask you, sorry to interrupt you on your way there, but I know you say that he hasn't applied the law correctly, but is there anything in his summary of the law that you say is wrong? And you may want to deal with that when you'll come to the judgment later.
I will come to the judgment later, my lord, but I can indicate that in his summary of the principles, I don't make any submissions that his summary is incorrect.
Thank you.
And as we'll see, he distills the Bouchereau principle into 4 sub-principles, and I don't take issue with them.
As a working summary for the purposes of this appeal and this action, sufficient.
Yes, my lord.
Thank you.
So I'm hesitant without firm instructions to say that it's a definitive statement of the law, but certainly I can indicate that I don't take, in my submissions, any issue with his exposition of the law. In my submission, it's quite helpful to go to the authorities first, because it saves us from looking at them whilst going through the judgment. And I hope this is the most efficient way to approach it. Yeah. The decision in Bouchereau was a case concerned with a Frenchman who was working in England as a motor mechanic. On separate occasions, he pleaded guilty to and was convicted of possessing dangerous drugs. So drugs-related offences. I think it was methamphetamines and LSD. In criminal proceedings, a metropolitan stipendiary magistrate was minded to make a recommendation that he be deported. But in those proceedings, Mr. Bouchereau raised a defence, saying that such an action was precluded under the law then in force, which was Council Directive 64221, which I will take the court to very briefly in a moment. The magistrate referred 3 questions to the European Court of Justice, and we're only concerned with the second question. And that question concerns the interpretation of Articles 3.1 and 3.2 of the 1964 Directive. And if I could just ask the court to turn back just 1 page in the bundle to the previous tab, we have Article 3 there. Article 3.1, measures taken on the grounds of public policy or public security shall be based exclusively on the personal conduct of the individual concerned. And 2, previous criminal convictions shall not in and of themselves constitute grounds for taking of such measures. That's what the court was concerned with. The key passage in this decision is actually taken from the opinion of the Advocate General, J.P. Warner. And the relevant passage is found on page 25 of the bundle, which is page 742 of the report. And it begins at the top of the page and goes down to the paragraph, I accordingly agree with the United Kingdom.
Sorry, can you give me the page again?
It's page 25 of the bundle.
Thank you.
Which is 742 of the report.
Yes.
And the relevant parts are from A to D.
The question is on the previous page, just for reference.
Yes.
And it's from this that we get exceptionally and public revulsion.
Yes, my lord. So
well, this is the origin of their place in the Bouchereau exception.
It is, my lord. Yeah. So it's really the sentence at C. So the United Kingdom in particular points out that cases do arise exceptionally where the personal conduct of an alien has been such that, whilst not necessarily evincing any clear propensity on his part, it has caused such deep public revulsion that public policy requires his departure. And yes, my lord, that really is the inspiration.
So it accepted, as we can see, the case as it was articulated on behalf of the government, the UK government. It looks like this is almost word for word. Yeah.
Yes.
I'm not sure the guest is necessarily a good analogy, but anyway.
Yes, my lord. I certainly wasn't going to read that part out.
No, I don't think.
It was perhaps a different time.
And in a sense, it's deep public revulsion that public policy requires his departure. I mean, it's strong words.
Yes, I accept it's strong words. My
But
lord,
it's not just, we don't like this. I mean, it's such deep public revulsion that public policy requires his departure.
I accept that, my lord. And my lord makes a point about words. I should just say it's not a point I'll develop in this authority, but if one turns over the page,
Yes.
to page 26, there is the Advocate General talks about difficulties in language and translation, and saying that in the paragraph by B, but its literal translation into English involving as it does the use of a phrase threat to public policy reads somewhat oddly, and he suggests that it's better to refer to a threat to the requirements of public policy.
Yes, that's picked up by the Court of Appeal.
It's picked up by Lord Justice Singh in the case of Robinson.
Yes.
Moving on, my lords, with this
Because
decision.
it's broader, that's what Justice Singh said.
He does, yes. And I will take you to that. Just for the court's note, the judgment itself begins on page 31 of the bundle, dealing with facts and procedure and so on. And the decision itself is at page 39 of the bundle. And the passages that are oft quoted in all of the decisions that we are going to be looking at, including Upper Tribunal Judges Grubbs, are on page 42 of the bundle, where you see that the second question is dealt with, and the key passages are paragraphs 27 to 30, as well as paragraph 35. And within those paragraphs, I just point out paragraph 29, where we get the exception. Because it says, although in general, a finding such as the threat exists implies the existence of individual concerned of a propensity to act in the same way in the future, it is possible that past conduct alone may constitute such a threat to the requirements of public policy. I understand that the outcome was then for the National Court to decide.
Yes.
In terms of the National Court, the first time that this court dealt with the matter is in the case of Marchand, which is over the page, tab 5 of the authorities bundle, at page 45. This is a case in which the exception is considered domestically. The case concerned a Portuguese consultant psychiatrist who was convicted of importing 4.5 kilograms of heroin into this country, and he was sentenced to 11 years in prison for that offence. He then sought to judicially review a decision of a tribunal which dismissed his appeal against a deportation order. And the deportation order had been made on the ground that his deportation was conducive to the public good. The lead judgment is given by Lord Justice Dillon. And if we turn to page 47 of the bundle, at the bottom of paragraph 2, final sentence, we see that this is a very grave offence.
And what made it particularly grave was that he was a doctor.
My lord, if I may answer that question more fully once by taking your lordship to the passage in this, in the way that it's described, in just a few moments. In this case, again, we can note at paragraph 11 that the Crown accepted that he had no propensity to commit further drug-related offences. And I then turn to paragraph 14, which is the paragraph that I submit answers my Lord Justice Stuart-Smith's question. And it has been interpreted in authorities later, but in my submission it's quite important to read it to understand it properly. It says, applying that principle, the offence which this present appellant committed was a very serious and horrifying offence in a field where there is grave danger from the use of heroin and the supply of heroin in this country. So the starting point is that it's very serious and that it's horrifying. That is the starting point. He then goes on to say it is an especially horrifying offence, repugnant to the public where committed by a doctor. The only point I make there is that it wasn't a fairly menial crime that was converted into a serious crime by him being a doctor. Rather, it was a very serious crime in the first place, a horrifying crime in the first place, which was aggravated by him being a doctor.
What was his involvement?
My lord, I'm not sure that it's that clear from the authority itself, but I think that I'm not sure that he was himself actually transporting the heroin. But if I may, my lord, I'll perhaps have a look at the authority when my learned friend is on his feet and answer that question.
Because one of the things that goes to the seriousness of drug offending is how close to the source you are.
Yes.
And if, for example, this doctor had been the person who brought it from the source into the United Kingdom, that would be one thing. If he was someone who had arranged for a courier to meet someone else and so on, he would still be guilty of the conspiracy offence, but it would be quite different.
I accept that, my lord.
Yeah.
And I'll perhaps try to look into
it says on page 46 he was convicted in the summary that he was convicted of importing 4.5 kilograms, and in the second paragraph he took us to conspiracy fraudulently to evade the prohibition of. So he was importing.
My lord, all I'd say is it's somewhat ambiguous in that he might have been importing by, as my lord indicates, by making the arrangements to do it, and he might have been the one that was physically getting on.
I know, I understand that.
But I'm not sure that we know whether he was the person getting on the plane or he was the person who was masterminding it all.
Yes, thank you.
Ultimately, Lord Justice Dillon in paragraph 16 concluded that the exception was met in this case and that his deportation was amply justified. That's the amply justified is the third line in paragraph 16.
And this was, so the appeal was dismissed.
Yes. The appeal was dismissed. It was found that this was such a case that justified the Bouchereau exception. Turning very briefly then to the judgment of Lord Justice Beldam.
So just to be clear, this is a case in which somebody practicing as a doctor in this country and is involved in a conspiracy to import heroin. And it's those combination of factors that give rise to the repugnance to the public.
Yes, that's my understanding, my lord. Whether he was practicing in Portugal as well, I don't know.
That was going to be my next point.
Yes.
I mean, there's a particular repugnance about somebody practicing medicine in this country and being involved in the importation of heroin that seems to have underlaid this decision.
Yes. Yes. My lord, I'm unsure as to whether he was practicing in this country or both countries.
I think it's clear he's practicing in this country because of what's said at the bottom of paragraph 2 of the judgment. He was a consultant psychiatrist at a National Health Service.
Oh, yes. Yes, my lord, that's correct.
So, yeah.
Turning briefly to Lord Justice Beldam's judgment, and I only do so to address the question raised with me earlier about fundamental interests, which is not in dispute in this case, but it is helpful to look at paragraph 19 of Lord Justice Beldam's judgment, which is at page 52 of the bundle. About halfway down the paragraph, he begins saying, I would begin therefore by considering what the fundamental interest of society in public policy was that the Secretary of State considered. And he says, it would be, in my judgment, be difficult to imagine a more fundamental interest than the unrelenting pursuit of the fight against deliberate, debilitating, and destructive influence of dealing in and importing into society addictive and lethal drugs such as heroin and cocaine. It seemed to be that even the hint that society was prepared to tolerate such conduct by accepting the presence of persons who had been prepared to import large quantities of such drugs under the cloak of legitimate business would undermine the overwhelming public interest in defeating this subversive trade. Moving on to the next authority, which was a number of years.
I mean, taken at face value, that you say that means that anybody convicted of any importation of addictive drugs in any country of the world would fall under the bourgeois exception?
I can't say that, my lord, no. I think the key is, which is stressed in the authorities, is that it is a very fact-specific assessment. So it's possible that one conviction of this sort might justify the exception, whereas another might not.
Would you accept that, as it seems to me, speaking in terms of myself, that passage in paragraph 19 is specifically directed at the impact upon this country of importation into this country, which is much more likely to, just looking ahead, to trigger feelings of revulsion and so on and so forth, than something which is entirely external and has no connection with this country?
My lord, I can see how...
but that's just looking at what Lord
Yes,
Justice
yes,
Beldown says,
I accept that.
that appears to be implicit in what he's saying.
Yes, I accept that point.
Yeah.
But my lord, the court had before it there a case concerned with this country. I wouldn't accept that it can be inferred from that in cases where such offences are committed in other countries...
Irrelevant. No, I'm not suggesting.
Okay, it obviously carries less weight. Again, so in answer to my lord's question, I would say that there are no hard and fast principles here. We're directed by the regulations. We can't just look at a conviction and make assumptions. One always has to look at the underlying circumstances of a case. And indeed, the thrust of my submissions is that one has to look at all of the circumstances holistically, cumulatively, rather than look at a particular crime in one's history and assess that and then move on to other actions later on. So, my lord, my answer to the question is simply no. There's no principle that if you commit a drugs-related offence of a particular sort, then you automatically meet the bourgeois exception. If I may...
Paragraph 20, he goes on to refer expressly to
yes,
that he was a consultant medical practitioner.
Yes, and the way that Lord Justice Belden puts it is that he says that an ordinary criminal who's not a doctor might not really understand quite the effect that these drugs have, but a doctor like him should have understood the dangers that these drugs pose, and it's his awareness of those dangers that compounds his actions.
I mean, I would have thought also is that if you've got, to pick up Lord's point, importation into this country by a doctor practicing in this country, then in a sense the likelihood of public revulsion in this country is sort of obvious because people trust their medical professionals in this country.
Yes, I accept that, my lord. Look, it will always be a matter of, it's difficult to speak in the abstract, but one can see how generally public revulsion would be greater if the actions concerned affected this country rather than actions committed in another country.
Well, it's like, it depends on what the facts are.
Yes, all depends on the facts. And
all depends on the facts. Thank
yes.
you very much. You took the words out of my mouth.
Yes, my lord. On that basis, if I may, I'll just jump ahead to the next authority.
Yes.
Which is at tab 7
Yeah.
of the bundle, and this is the case Conjoined Appeals, decision of this court in 2015 of Stuart-Smith and Keresis.
Yes.
In this case, Mr. Stuart-Smith had attacked someone with broken glass and assaulted women, and Mr. Keresis had committed identity fraud, taking advantage of elderly people. Where it differs from this case, in one respect, is that these individuals had a permanent right of residence in this country, and all I need to say is that it's more difficult to expel those with a permanent right of residence. One has to identify serious grounds rather than just grounds. Now, in this case, orders were made against both of the individuals, and the decision concerns the 2006 regulations rather than the 2016 regulations. But in my submission, nothing really turns on that. They have been amended over the years, particularly to take account of decisions. But they are different regulations and the numbering is slightly different. I turn first to the judgment, which I think is the lead judgment of Lord Justice Moylan, and turn to page 80 of the bundle. I need not read it out, but I simply indicate that at paragraph 15, this is where his lordship deals with the Bouchereau exception and sets out the relevant passages. What one passage that I would take the court to is in paragraph 70, after the indented quotation at E. He says, "This seems to me to emphasize the need to look to the future rather than the past in all but the most exceptional cases, and to emphasize the importance of the right of free movement. As I agree with Mr. Drabble that one can detect in the decision an understandable element of pragmatism in the recognition of the right to deport those who have committed the most heinous crimes, which is at odds with the principles of the directive." And that is a passage that is relied upon in subsequent decisions. In paragraph 18, he deals with the Marchand decision. And paragraph 20 is important in that his lordship formulates what the exception is. And if we start on the fourth line of paragraph 20, it says, "The authorities to which I have referred support the general proposition that great importance is to be attached to the right of free movement, which can be interfered with only in cases where the offender presents a serious threat to some aspect of public policy or public security." Then he says, "Save in exceptional cases, that is to be determined solely with a reference of the conduct of the offender." And then I note the words in parentheses here. He says, "By reference to the conduct of the offender, no doubt viewed in the context of any previous offending and the likelihood of re-offending, full stop." And all I note at this point is that Lord Justice Moylan seems to be taking a holistic view of conduct. He's not saying you look at one criminal conviction and assess it by itself, but rather you look at it in the context of any previous offending. And I would say that equally would apply to any future offending. He goes on to say, "General considerations of deterrence and public revulsion normally have no part to play in the matter. In these respects, the principles governing the deportation of foreign criminals in general differ significantly from those which govern the deportation of EEA nationals who have acquired a permanent right of residence." And that picks up on the point that my lordship raised with me earlier as to the importance of these regulations and freedom of movement. Turning to a minor point made in paragraph 25, and he talks about the assessment and the task at hand, looking at fundamental interests, and says at line by H, "That requires an evaluation to be made of the likelihood of the person concerned will offend again and what consequences are likely to be if he does. And commenting on that task, he turns over, if we turn over the page to the second line on the page, he says, in any given case, an evaluative exercise of that kind may admit of more than one answer. If so, provided that all the appropriate factors have been taken into account, the decision cannot be impugned unless it is perverse or irrational, in the sense of falling outside the range of permissible decisions. The court dismissed the Home Secretary's appeals and found that the exception was not met in either of those cases. The final authority I wish to...
Just before you leave that, I mean, there were two parts of it that I've noted. One, in paragraph 14, which I don't think you did this to, just before the end of the paragraph, he says similarly, he talks about deterrence of others, and then he says it's difficult to see how a desire to reflect public revulsion at a particular offence can properly have a part to play, save perhaps in exceptionally serious cases. Is that right?
Yes, my lord.
Right, and it's sort of, in a sense, he picks it up again at 31, last page. He sort of summarises, I think, the approach that he adopts. I don't think public revulsion of the offender's conduct has any part to play in deciding whether there are sufficiently serious grounds for public policy to justify his deportation, save in exceptional cases of the kind in which failure to remove the offender might itself tend to undermine confidence in the state's ability to administer justice. And is that another way of looking at it, or where does that fit?
Yes, my lord. I would say that all of these ways are ways of expressing what's most commonly referred to by the phrase, what's picked up most commonly by Lord Justice Moorbeek's judgment is the phrase the most heinous of crimes. And in my submission, the passages that my lordship has taken me to are simply different ways of expressing that it is an exceptional course and the crime has to be serious.
Would it be your submission that arranging to introduce a courier to someone else for a fee of $1,500 is the most heinous of crimes?
My lord, I don't have a submission on that as such, because...
I don't understand that answer.
My lord, well, my submission, my answer to that question...
I understand your submission to be that if you look at all his conduct,
yes,
it tips the balance. But it is worth knowing whether you are submitting that viewed on its own, if the upper tribunal was justified in taking the view of the facts that it did, which I don't think you're in a position to dispute, then the question arises, do you say that that was the most heinous of crimes?
my lord, I'd better take instructions, but my preliminary answer is no.
Okay. Do you want to take instructions?
My lord, the benefits of live streaming are that my solicitor will take instructions on that point. You have my preliminary answer, but it's important that I take instructions.
Yes, yes, of course. Thank you.
It's meant to be a difficult question. Or it's not meant to be a difficult question to formulate, it's meant to be a question which might be difficult for you to answer.
Yes.
Whilst you're at it, can you similarly take instructions on whether filling in the wrong answers on applications such as we saw immigration applications is also to be regarded as the most heinous of crimes?
On its own. Given the finding that the purpose was to get to see his wife.
Yes, I'll take instructions, my lord. Again, my preliminary answer to your lordship's question would be no.
And then whether you can also take instructions on whether 0 plus 0 equals 1.
Yes.
I think we know the answer to that because that's your submission. If 0 plus 0, or if whatever plus whatever doesn't amount to 1, you lose.
Yes, but my lord, I would take issue with the assumption there. I would say that it might be 0.01 plus 0.001, but I wouldn't say that it's 0.0 because one and this goes to the heart of the appeal, my lord. So perhaps I'll make this point now and return to it.
Yeah.
Which is this: that one can see my lord's point that lying on an application form once off is unlikely to be the most heinous of crimes. So if one is looking at the Boucher exception, and you take the approach that upper tribunal judge took, and you just focus with blinders on the one crime, the next, and the next, that has the effect of making lying on an application form irrelevant to this assessment. And of course, the reason my client brings this appeal is because he is concerned about lying on application forms and about how this fits in with the whole regime. So, my lord, what I say is that if you take 0.01 and add, you must still just not make an assessment in respect of the one. Adding that 0.001 of the application form might tip the balance. And this appeal is about the approach that the judge took. It's important for my clients to work out when making these decisions, does one look at all of these things, or does one, as the judge did, simply look at lying on an application form and just throw that out the window, because in and of itself it's not a serious or heinous crime.
Thank you. So the next authority?
The next authority, very briefly, is the case of Robinson at tab 10, which is another decision of this court, a judgment given by Lord Justice Singh. I should say that the vast majority of this decision is not relevant for present purposes. It deals with a Jamaican national who had indefinite leave to remain in this country, who was convicted of the criminal offence of supplying cocaine. And whilst various immigration proceedings were ongoing, she gave birth to a son who happened to be an EU citizen. And for that reason, she acquired rights and the regulations came into play. And much of the decision is concerned with how one applies the immigration rules and Article 8 and so on. But Lord Justice Singh does deal, as issue 3 of his decision, with a Bouchereau exception. And that's at page 144 of the bundle.
Yes.
We've already looked at much of it. Paragraph 68, he goes to Bouchereau. He looks at the Advocate Warner's passage that we looked at. He looks at all the passages that we've looked at already. The key paragraph there is paragraph 71, which the court has already alluded to. In which it said it's important to recognise that the ECJ there was talking about not a threat to the public, but a threat to the requirements of public policy. The latter is a broader concept. It is somewhat awkward phraseology, this threat to public policy, because it does conjure up images of a real threat to the persons of this country. But that's not what we're looking at. It's more that would this person, would admitting or allowing the person to be in the country undermine the fundamental interests of this country?
It's sort of why I took you to paragraph 31 of Lord Justice Beck's decision in Strasuski, where he talks about undermining confidence in the state's ability to administer justice. That's the sort of
Yes, my lord.
Sort of concept, isn't it?
Yes. It is, my lord.
Certainly an aspect of it, anyway.
Yes. And I won't read out, but I ask the court to take note of the remainder of paragraph 71.
Yes. And you don't, you accept that that's an accurate summary of the
yes.
State of the law?
Yes.
Yes.
And that leads naturally to paragraph 80, in which Lord Justice Singh said, I'm of the view that the decision in Bouchereau continues to bind the courts of this country. And then the key passages, again, are 84 and 85, which I won't read out, but ask the court to read.
don't dissent from 85 either.
No, and Lord Justice Singh there makes the point that we were traversing earlier on about whether there can be hard and fast principles as to whether drug offending meets the exception or not, where the Lord Justice declines to offer any exhaustive definition. And his example is grave offences of sexual abuse or violence against young children. And again, that's a passage that's relied upon. I think my learned friend, and certainly in the authorities. And ultimately, in paragraph 86, we need not read, the conclusion is reached that the exception was not met in that
Yes,
case.
yes.
Moving on to my submissions, my lord, which I propose to make by taking the court through the judgment, and for the moment we can put the authorities bundled away.
Thank you.
I will refer to one more authority in it, only briefly. But now turn to tab 8 of the core bundle. This is the decision of Upper Tribunal Judge Grubb that is under appeal. From paragraphs 3 to 14, he sets out the factual basis. In paragraph 14, he sets out the scope of the appeal before him, which was applying the Bouchereau exception.
And we see him there saying, arising from both his conviction and his conduct subsequently in failing to disclose.
Yes, my lord, and that conjunctive approach is reflected in the Secretary of State's submissions, which he records later, and I'll take it to court.
Yes.
The law is set out at paragraph 15 to 30. As indicated earlier, I don't take or make any particular criticism of his exposition. I would just note at paragraph 18, and my taking the court to this paragraph has less relevance than it did before you refused my application to amend.
Right.
But that deals with the length of sentence.
Yes.
That must be taken into account.
Yes.
Paragraph 19, more importantly, the judge is aware of the fundamental interest at 7A of preventing unlawful immigration and abusive immigration laws.
Yes.
At paragraph 20, he refers to a test which is not disputed, 4 stages. And the only point I wish to make is that paragraph 21, he says, what is the relevant personal conduct of the individual? Now, as is plainly clear, conduct in English can be both plural and singular. It can be one act that constitutes conduct, or there can be 2 acts that constitute conduct. So it's somewhat ambiguous, and that doesn't help us answer the question that's raised in this appeal.
But is it? First of all, he identifies that 7G and 7A may be engaged.
Yes.
And then he says the issue is whether the appellant's conduct, which must be referring back to all the conduct that he's just referred to.
I don't think conduct is a word that has a plural.
No.
Because it has conducts.
Yes, or counsel. Or the word counsel. So in my submission, conduct can amount to one act or many acts.
Yes. But well,
It's
not how I read it. The first sentence, he's saying conduct as an entirely general question.
My lord, the first sentence
fall within 27.5c. Then he says you can look at the bits and they both engage particular issues.
Yes.
And then he goes back to the generality. He says he looks at the appellant's conduct represents a genuine, present, and sufficiently serious threat to one or more of those fundamental interests.
Yes, my lord. My lord, the point I make is that this is his exposition of the law, with which I don't take issue. It's how he applied it later on in the judgment.
Okay.
Right.
At paragraph 20, sorry, I've taken the court to that. At paragraph 21, as my lordship has pointed out, drug offending and immigration deception fall within the fundamental interests. At paragraph 22 to 30, he deals with Robinson.
Yes.
27 to 30, he distills 4 principles. And then 30, at paragraph 30, he proceeds on the basis, on the last line before the quotation, that there must be an overall assessment of the individual's past offending, its circumstances, and his subsequent conduct.
So you would say that's the right test.
I would say that that's the right test, yes.
So he has at least asked himself the right question.
He has asked himself the right
So
question.
so he gets the law right. He asks himself the right question. The narrowness of this appeal is shown is that you say, having clearly had the right test in mind and identified the right question for himself, he then doesn't answer it.
Yes.
Okay.
He doesn't follow the approach that he has set out for himself.
Okay.
And he seems to remind himself several times. It's not just a one-off in 30.
Yes.
It's front and centre.
Yes, my lord.
If it's of any interest to you, which it might be, I've identified paragraphs 8, 11, 12, 37, 48, 53, 55 and 60 as occasions where he reminds himself of what he's meant to be doing.
I'm grateful, my lord. And I would point out that, ironically, in paragraph 60 itself, he's flatly going against what he suggested. And I'll take my lordship to that.
Okay.
And paragraph 31, where we get to his application, he records the first-tier tribunal judge's finding that there's no propensity in respect to further drug offences. And then we see how the Secretary of State advanced the case in front of the judge at paragraph 33. And this is a point already made to me this morning. It says, in addition, Ms. Ruthworth pays some reliance upon the appellant's immigration history involving deceptive, and this is a typo, deceptive directed at the UK immigration authorities. So that's the case. The case is that in addition they be looked at together. And the case is similarly put like that and recorded at paragraph 37. Again, maintaining her argument on both bases, both in relation to the appellant's criminal conviction and deceptive conduct.
Yeah.
A very quick detour, if I may, my lords, when we get to paragraph 34. And I should indicate that I should finish my submissions certainly quite soon, well before lunch. A quick detour to the first instance decision.
Yes.
Which is at tab 14, and that's the decision of first-tier tribunal Judge Moylan.
Yes.
And I'll just pick up a few points in it, hopefully in as much order as I can, following the judgment from start to finish. It's notable, if we turn to paragraph 69, which is on page 93 of the bundle, that at this point, he is still saying, I did nothing wrong. He notes that I was arrested for credit card abuse and assault, but no charges. I do nothing wrong.
Sorry, which paragraph?
Paragraph 69,
69,
bottom of
thank
page
you.
93. And then a similar thing is said on page 70, where he talks about helping the FBI, and he said, I do nothing wrong. By which
Yes.
I understand mean I did nothing wrong. However, as the hearing proceeds, if we turn to page 100 of the bundle,
Yes.
at paragraph 118, he accepted there during his evidence that what he did was wrong.
Yes.
Then I just want to point out...
Albeit he contends he played the role of a mule.
Yes. And there seems to be a little bit of ambiguity as to whether he was the mule or he was finding a mule.
Well, I mean, one of the issues in this case, you're stuck with factual findings because the Secretary of State didn't produce any different evidence.
Yes, my lord, I accept that. The upper tribunal judge describes it as a paucity of evidence. The respondent didn't put in evidence as to the nature of this crime and the circumstances. I don't have full instructions and, of course, wasn't involved as to why that was the case. I can only imagine that it's very difficult to obtain that kind of information.
But it doesn't matter.
It doesn't matter.
The problem is the burden is on you.
Yes.
You didn't have any evidence for reasons good, bad, or indifferent.
Yes, my lord. What I would say is that what evidence I have is actually provided to me by the regulation itself, which says that you can take the length of sentence as at least some evidence as to the seriousness of crime.
Yeah.
And that's in 27.8. And I say that the regulations there are pragmatic in accepting that in these kind of proceedings, the Secretary of State might find it difficult to obtain evidence, but certainly one starting point, one factor, one piece of evidence is an important inference that if someone is sentenced to a lengthy crime, that is evidence, at least prima facie, of conduct which merited such a lengthy sentence. And I'll take your lordships briefly to an authority on that point in a moment.
Right, thank you. So have we finished with the first-tier tribunal?
Not yet, my lord. Very quickly, I just noted paragraph 86 of the decision.
86.
That the Secretary of State, again, advances the case on a cumulative basis.
Yes.
Saying there's a threat on the basis of a conviction as well as his failure to disclose. And then I point out very briefly at paragraph 68 that at the time of the hearing, Mr. Okafor was still lying, saying that he misread the question, he didn't mean to deceive anyone.
Well, except 125.
Except 125 provides
during cross-examination.
That in cross-examination he finally, and the word finally is used there.
Yes.
But I take that into account, and in paragraph 125, the judge notes a significant misrepresentation.
Does this matter? We've got findings of fact which you can't overturn.
No. One finding...
I mean, it's nice prejudicial stuff from your point of view, but...
One finding of fact, which I do note here, which I submit is important, is a finding made by first-tier tribunal Judge Moylan, but I would say is misinterpreted by upper tribunal Judge Grubb.
That's paragraph 137.
It is. And if we turn to that, my lord, and it's a minor point, I won't detain the court too long with it. The first, that's on page 102 of the bundle.
Yes.
There's a discussion about him being released on immigration bail, and then since he's been released, he hasn't committed any further offences. And then 137 says, having regard to the evidence as a whole, I find that it's not likely that the appellant will re-offend in the future. He's not been shown to have an intentional desire to re-engage in criminal conduct, etc. Now, there the words use of criminal conduct and offend. He didn't offend by lying on his application form. And the question is, does he have a propensity? Is he likely to lie again on immigration forms about his immigration status in order to be able to see his wife? Well, what better evidence of lying again is there than lying before the first-tier tribunal? So, in my submission, first-tier tribunal Judge Moylan, in paragraph 137, was not making a finding that he had no propensity to commit immigration fraud in the future. He was repeating his earlier finding that he had no propensity to commit a drug-related crime in the future. In the context of the decision, that, I submit, is the natural interpretation of it. Especially, as I say, in circumstances in which the deception has occurred recently, and
is lying on an immigration form not a criminal offence?
I've made inquiries about this, my lord, and as far as I understand, it isn't. Our instructions are that it isn't a criminal offence.
Right. Okay.
That might be the case that because many applicants are applying from abroad, and how would one prosecute them and so on. But as far I don't want to give the court a definitive answer to that. But I've taken instructions upon this point, and as I'm informed, no.
If you used a false passport, that would be a criminal offence.
Yes.
Using a false instrument.
Yes. So I don't know quite how using these drop-down menus. It might be, your lordship points out, it might say at the bottom of the form, providing inaccurate information is criminal conduct. But I haven't been told of any specific offence.
I think I ought to suggest to you that the last sentence of 137 is effectively saying, if you take out the particular circumstance of him wanting to be with his wife, there's no evidence that he would be likely to lapse so as to breach the United Kingdom laws if he considered it expedient to do so.
Yes.
So if you take out the problem of wanting to see his wife, which no longer subsists, then he's rehabilitated.
Yes, my lord, but his family permit would have expired a couple of years later, so the problem might have re-emerged.
Can I just point out that the end of the form, for example, at page 82, says, I understand that if false information is given, the application can be refused and I may be prosecuted.
Yes, my lord. I
Which
suspect
might suggest that
which might suggest,
somewhere or other it is an offence.
Yes, my lord. I have to accept that. I'm unaware of what specific offence it is, and I have taken
Right.
instructions on that.
I mean, if you're making the submission that criminal conduct cannot, in any circumstances, be referring to lying on immigration forms, I think you'd have to give us a little bit more detail
Yes.
to sustain that submission.
Yes.
Speaking for myself.
I appreciate that, my lord.
Thank you.
But it doesn't matter to you, does it? Because your submission remains that it's reprehensible conduct which shows a deceptive and dishonest frame of mind
Yes.
in the recent past, which when taken with the facts of his criminal behaviour should have tipped the balance.
Yes. It's not a substantial point, and for that reason, my lord, let's leave this decision and return to the decision under appeal, which is back a few tabs at tab 8, and just almost at the key submission that I've already made, but will repeat. But paragraph 39 to 44,
Yes.
the judge sets out positive conduct in Mr. Okafor's failure. Really a minor point that I just note.
Sorry, you've not gone back, I thought, to follow through. Did I miss it? About paragraph 35. I mean, that's not within your. Is that within your round of appeal? I mean, do you say that 35 is wrong? And yet, are you entitled to say 35 is wrong?
My lord, the answer to that is, I say that 35 is wrong. I accept, much like I had to accept earlier in this hearing, that there's no ground of appeal in respect of that particular error. And in respect of that error, for the reasons given by Lord Justice Stuart-Smith, I don't seek to amend. I was merely pointing out to the court that there was some ambiguity. And it's not a point that I'm in a position to follow through on, for the reasons given by my lordship earlier, about the possibility of there being a criminal offence.
Okay.
So 39 to 44, there's some discussion of positive things said about Mr.
When you say positive things, it's partly putting the conviction in context.
Yes.
Right.
And that relates to the passage we looked at Schedule 1 about positive evidence in favour.
Well, I think it's a bit difficult to. I wouldn't compartmentalise it in that way. This is just putting the offence in context.
Yes, my lord. I accept that.
You've got the headline, 350 months,
Yes.
and this is a more detailed analysis of the nature of the offence.
Yes, my lord.
Yes, thank you.
I make a very minor point only for the court's note. Again, it's not a ground of appeal. That in paragraph 44, there's a reference to the Fair Sentencing Act of 2010. And for reasons pointed out in footnote 12 of the replacement skeleton arguments, that act doesn't actually apply to heroin offences. There's no point made in that. I just make it for the sake of completeness because it's made in this replacement skeleton.
Right, thank you.
But he didn't put weight on that.
He didn't put weight on it in any event.
Right.
Paragraph 45 to 46, we see how the claimant's counsel advances the case. She says that on the basis of the limited facts known about the appellant's offending, and there she's speaking about his drug-related offence, the Bouchereau exception was not established. Then she further says in paragraph 46, the appellant's past deceptive conduct did not reach the level of public revulsion. So she's adopting the separate approach there.
Yes.
Dealt with Marchand at 47.
Yes.
Then there are various points, my lord, which I have to abandon. I'm just turning ahead, and these relate to the failure to deal with the sentence, which is dealt with in the skeleton argument, but for which I don't have permission to proceed. So I will leave those out, which saves a considerable amount of time. And really jump now to a very short submission, which is the heart of the appeal. This is where I developed the submission that the judge got the law right, but he misapplied it for whatever reason. And we see this in his judgment, where if we look at paragraph 58,
Yes.
he is assessing personal conduct, and he looks at the appellant's offending, and he's talking about drug relation. Here the appellant's offending, though serious, and his role, like the offence itself, should not be understated. It was not offending which falls within the exceptional or unusual category that invokes the Bouchereau exception.
But you start at the first sentence. It's important, in my judgment, important to take all the factors I have identified into account. And all the factors include, sorry to be rather superficial, all the factors.
Yes, my lord, but then he's not identifying...
You say even then, although he identifies the right test at 58, that you need to take into account all the factors, he hasn't in fact done so.
Yes, my lord.
Right.
He is making a clear finding here that the drugs-related offence does not meet the Bouchereau exception. There's no talk in this passage or in the previous passages about immigration deception. And if we turn over the page to 59...
50? Oh, yes, sorry.
Sorry, it's paragraph 59.
Yes.
There's a final conclusion that the Secretary of State has failed to establish on the balance of probabilities that the Bouchereau exception is met. But to make whole my point, my lord, we look at paragraph 60. And here, the court is finally dealing with immigration deception.
Yes.
And says to the extent that it's relied upon, he accepts that it could be a fundamental interest, and says that that conduct comes nowhere near falling within the exceptional or unusual case contemplated by the Bouchereau exception. So, my lords, my submission is that in order to have approached this in the correct way, the judge would have had to have dealt with them together, said this is the conduct, the crime, original crime, this is the deception. Looking at it all together, I come to the conclusion that this conduct does not reach the relevant threshold. But what he did is he says, I looked at the drugs, I'm taking all factors into account, let's look at the drugs-related crime and assess it, and he says that crime does not meet the standard. And then he says, oh, and also, let me return to the immigration deception, that too does not meet the standard.
Yes.
And that really is the heart of...
That's your case?
That is my case.
Right, can I just ask you this? Firstly, what you're really saying is he's missed out one sentence which says, singly and cumulatively, it doesn't meet the test. If you put that in, we wouldn't be here.
Well, I think he would have to rewrite the judgment somewhat, my lord. I think he would have to move paragraph 60 above where he reaches a final conclusion. He would need to deal with immigration deception before he says that the standard is not met.
What would your response be to a suggestion that what he's really saying in paragraph 60, to use a technical term, is the deceptive conduct doesn't add up to a row of beans?
Apologies, my lord, the deceptive conduct?
Is of no consequence because it comes nowhere near.
Well, that...
Technically, it may be possible to put it into subparagraph A, but it's nothing.
My lord, if he had said, in reaching my conclusion that the Bouchereau exception is not met in relation to the drugs offence, I have taken into account the fact that recently he has committed immigration fraud, and those together do not amount to meet the standard, I would accept that as the lawful approach. But my submission is that he's not taking that approach. He is looking at them myopically. He's looking at them separately. And I can't take my case further than that. What I was going to say in concluding remarks, and I just make them now, is that what the judge does here in the approach that he actually takes, rather than the approach that he says that he takes, is he deprives immigration deception of the ability to be a tipping point. His approach, if adopted regularly, would mean that because immigration deception might not in and of itself cause public revulsion, it's irrelevant in the assessment of the Bouchereau exception. And the Secretary of State's case is that when reaching a final conclusion as to whether the exception is met, all of those things have to be taken together. And the importance of the appeal really lies in that.
I think it's a bit dangerous to start extrapolating, because you might, as you know, my Lord's adopting expression, be careful what you wish for. It's not what he's saying. He's just saying this conduct comes nowhere near falling. So it's fact specific.
Yes.
He's not saying deception of itself can never. He's analysing the specific nature of the conduct. I understand your point about cumulative rather than compartmentalised, but he's not seeking to lay down any general principle.
No, my lord. I'm not making that point at all.
Right.
The only point I'm making is that in cases such as this, where you might have immigration deception, if judges approach the question the way that upper tribunal judge has approached it, immigration deception is likely to play far less of a role, simply because if it's looked at in isolation as lying on one form would cause public revulsion. I make no general proposition, it depends on the facts, but it might be hard to...
I see.
All I'm saying is that it's important that when looking at the exception, it's taken into account in the broader picture, because otherwise immigration deception tends to be left out of the consideration.
Yes.
So that even if we're against you on the facts of this case, you'd like to see a sentence in a judgment which says that, at least in theory, immigration deception, in an appropriate case, depending on the facts, taking the rough with the smooth, at the end of the day, taking all relevant matters into account, is not incapable of being a tipping point.
Yes, it might provide the tipping point. You know, if you can imagine...
It is capable of providing, or it is capable of influencing the outcome.
Yes, yep. That's the only point we're making.
Right. Have you got instructions? No.
No, I'm sorry, my lord.
Okay.
You have my provisional
Any other questions?
views. No. My lord, I haven't dealt with, and perhaps I don't need to deal with, the respondent's notice, which raises...
Why didn't you deal with that in reply once we've...
Certainly, my lord.
Any questions?
Just going back to paragraph 37, this is how he summarised the argument on behalf of the Secretary of State. As summarised,
yes,
the argument on behalf of the Secretary of State, picking up my Lord's point, is that the way you would... We don't know what the Secretary actually said.
yes.
But how should the Secretary of State's argument be recorded? Is there something wrong with the way it was put in paragraph 37?
Prima facie, my lord, I wouldn't say that it's wrongly expressed there. It could be better expressed. But the point is that the conduct relied upon involves two things that have to be assessed together as one.
See, that's the argument he's dealing with. He's recorded it, and if you're happy that the Bouchereau exception is assessed by reference both to criminal conduct and deceptive conduct, then that's how the judge starts this analytical process with the right question.
Yes, I accept that. He records correctly, as did first-tier tribunal Judge Moylan, that what the court is being asked to do is really reach a holistic assessment, based on both of those actions. But my lords, perhaps if I make the point this way, we could imagine a case in which a person has committed a number of offences of varying natures, drugs-related, perhaps grievous body assault, etc., each of which does not, if analysed by itself, meet the Bouchereau exception, such as to cause public revulsion. But it might be the case that if there are a series of convictions and the Secretary of State puts in evidence, giving evidence as to what particular crime was committed and the circumstances of it, one could see how one conviction of itself might not be enough, but taken all three together, it might well be enough.
Yes, thank you. I think we've got the point.
I'm grateful, my lord. Unless there's anything further, those are my submissions.
No. Thank you very much indeed. Thank you. Very clear. Yes, Mr. Chatterjee.
My lords, if I could perhaps start by just going to the authorities with respect to the actual nature of the exception, and I of course accept that my lords have been taken through
Yes.
those authorities
Yes.
at some length, so I won't dwell on them. The facts are not in dispute. My intention is to just take my lords through the test, the approach that the Court of Appeal should take when considering a decision of the upper tribunal, which is of course an expert specialist tribunal, and then the decision itself. As far as the authorities are concerned, my lords have already seen the decision in Boucher. I don't need to take my lords through it again. It's relatively light on the nature of the test itself, actually, and one gets more insight from the short passage of the Advocate General's opinion than one does from the judgment itself. But I would like to take my lords to the decisions of the Court of Appeal. My lords have already seen Marchon, and that is, as my lords will have noted and has been remarked in later cases, a relatively old decision. It's a 1993 decision. It predates the coming into force of the 2004 directive, and of course Bouchereau far predates the 2004 directive as well, and relates it to the 64 directive, 64221. And my lords have the provisions of the 2004 directive that are relevant in the authorities bundle at pages 9 to 12. That makes, and one can see by contrast with the 64 directive, far more extensive provision for public policy decisions in an EU law context, with far more detail, adding in expressly the requirement for decisions to be proportionate, and various other procedural safeguards. And of course it postdates the decision in Bouchereau, so one would expect that it also factors in the fact of the decision in Bouchereau. And then afterwards we get to the more recent decisions, and the first one is Straszewski, which is at tab 7,
Yes.
page 73 of the bundle.
Yes.
And my lords, this sets out, and I won't take my lords through the relevant passages in detail. I'll refer my lords to the passages so my lords can consider them when considering the case. But paragraph 9, well, you've already been taken through the facts, but paragraph 5 sets out the facts in Straszewski, and it is a serious offence, clearly, and it also contrasts the deep public revulsion element in terms of as between offences. So offences can lead to longer sentences, but other offences might lead to more public revulsion because of its nature. And the Straszewski offence was a violent offence against two women in their home, and therefore one can see that might cause more in terms of a reaction from the public, whereas there might be a sense of déjà vu and not such revulsion to offences that are far more commonplace and perhaps don't have such an impact on the on individuals. Paragraph 9, submission with respect to the difference between the domestic immigration regime and the EU regime. At paragraph 10, you have the circumstances of the offence in the Kersey's case. And then paragraph 11 is important because it was a submission about deterrence and public revulsion. The court clearly concluded that ordinarily one does not look at revulsion and deterrence. It is the propensity to re-offend and the future that one is looking at. Paragraph 13 reference to the fundamental nature of the right of free movement, and that any derogations from that, and that includes the public policy ability to interfere with that right, must be construed restrictively. Paragraph 14, I think my lords have already seen this. Deterrence has no part to play in a public policy decision under EU law. And the desire to reflect public revulsion also has no place except in exceptional cases.
Which paragraph are you at the
exceptionally
moment?
serious. Paragraph 14, my lord.
Thank you, yes.
And then paragraph 15, there's reference to Bouchereau. Paragraph 16, reference to the Advocate General's opinion. And paragraph 17, in my view, the clear emphasis of that passage is on the fundamental nature of the principle of free movement and the need to identify a present threat to the requirements of public policy, while recognizing that there may be cases in which past conduct alone may suffice, but suffice to establish a present threat to the requirements of public policy. And then again, after the quotation in the same paragraph, the emphasis on the need to look to the future. Then at paragraph 19, the court considers a later case from the Court of Justice, the case of Nasli, and concludes at the bottom, at the last sentence, I can see some force in Mr. Drabble's submission that the decision in ex parte Marchand can no longer be regarded as representing community law. One doesn't need to decide that. The respondent's submission is not that it doesn't, but it just does. It's important to bear that in mind. The history of it, of course, my lords have pointed out that the facts of that were very specific, and what was relevant from the facts in terms of the court's analysis was very specific in terms of the offence being committed in the UK, being committed by a consultant psychiatrist, and the nature of revulsion that would cause amongst the public, because a senior doctor would expect to know the consequences of drug dealing and would not be expected to take part in
The
it.
test is present threat of sufficient seriousness.
My lord, yes.
That depends on presumably current revulsion, which in turn depends upon the specific facts of the given case.
My lord, yes.
And so for that reason, comparison with other cases is
Very difficult.
limited.
Yes. And in
Limited.
Marchand, of course.
Sorry.
Yeah, go on. I've done.
Sorry, no. You.
Oh, I was going to say, my lord, that in Marchand, of course, the offence was relatively recent because it was committed in the UK, and there was then a desire to deport after the end of the sentence. We have a very different set of factual circumstances here because the offence is so old, so remote, and of course committed many thousands of miles away.
But, and this is what I was going to pick you up on, you slipped, I think, into your submission a little while ago, a moment or two ago. You said even when you're looking at the past offending and the question of public revulsion, that's forward-looking. And I suggest that doesn't seem to be right, because in paragraph 17, which is where you were reading when you made the comment, it has to be a present threat to the requirements of public policy, but there may be cases in which past conduct alone may suffice. And I think, isn't it the case that what they're saying is, even if somebody is not likely to offend again, there may be some past offending which is so heinous that society will currently be sufficiently offended that it justifies.
Yes, my lord, I accept that.
Yeah.
But again, it has to be a case of society currently being offended by it.
Correct.
And it might be that that offending is very remote. And one does get exceptional cases where the offending is so notorious that any current action in relation to it does give rise to a public reaction. But one has to look at the current public reaction.
Yeah.
All of the cases
I mean,
refer to deep public revulsion.
There are some individuals whose offences, although committed a long time ago, are still regarded as so heinous that in this sort of context you would say public
Yes.
faith in the system.
Yes.
I'll put it. That's why there's a paragraph in one of the other judgments. Society's present faith in the system would just be
Yes. Undermined.
Undermined.
My Lord, yes,
they were to make-
I accept that.
Yeah.
But of course, the respondent's case is that this is far removed from that type of case, but for all of the reasons that the upper tribunal has set out, and which I will come to in due course. But of course, as a matter of principle, I accept that remote offending, in terms of it taking place many years ago, can still have a present effect. But what I say is that there needs to be a present effect, because that is the focus of...
Yeah, I think I was just picking up because I think you
Yeah.
did say at one point that there was an element of looking to the future in all of this. And I
Yes.
don't think that's quite right.
I took my Lord to paragraph 19 and the last sentence. I think just at paragraph 21, the last sentence of that, again, in relation to Straszewski's case on the facts, serious though the offences were, it is regrettably not difficult to imagine offending of a much more serious kind. And that's the sort of analysis that needs to take place. One doesn't simply focus on the fact that it's a serious offence. One has to focus on how serious, because it's deep public revulsion, and we're looking at an exception to the otherwise policy under EU law, which is to look at propensity to reoffend. If I could then take my Lords to the decision of the Court of Appeal in Robinson, the judgment of Lord Justice Singh, page 142 of the bundle, where the relevant section begins. Sorry, it's not. It's 144.
Yes.
Where the relevant section begins, and the relevant paragraphs in my submission are really from paragraph 71 onwards.
Yes.
Yes.
And I'm just going to focus on the adjective used, because Lord Justice Singh quotes from previous judgments, and I think the adjectives tell us the nature of the test. It's an exception, and one has to ensure that one understands the nature of the exception. So paragraph 71,
Yes.
when looking at the decision in Bouchereau, Lord Justice Singh refers to the deep public revulsion, which was the adjective used by Advocate General in that case in his opinion, and describes it as the kind of extreme case in which past conduct alone may suffice.
Yes.
Paragraph 74, referring to the judgment in Straszewski, Lord Justice Moorbeek saying that such cases would be exceptional, and referring to, in particular, public revulsion.
Yes.
And then at paragraph 84,
Yes.
again reference to an extreme case and past conduct which has caused deep public revulsion. And at 85, the last part of that paragraph where Lord Justice Singh gives an example, the sort of case that the court was thinking, the person has committed grave offences of sexual abuse or violence against young children. So that's putting the bar in my submission in terms of public revulsion high, and it's related to public revulsion because, of course, there can be grave offences that don't need to be committed against children, but it's the deep public revulsion element in my submission that led Lord Justice Singh to give that as an example.
He upgrades in 85 to very extreme.
Yes.
Previously he said extreme.
Extreme. Then, my Lord, yes, very extreme. And at 86,
I don't know where we go from very extreme, very, very, very extreme.
And of course, there is, of course, public revulsion and what the Advocate General said, which was deep public revulsion. So it's revulsion by the public, but it's deep. So it's an exception, it's a high bar. 86, deep public revulsion at a past offence. And then what Lord Justice Moore-Bick said in Strzelecki, which is the most heinous of crimes. And again, that gives an indication of the sort of offence the ECJ had in mind when it said that a past offence alone might suffice.
Yes.
And I think, I'm sure my lords get it, the point is that it's an exception, it's a high bar, it's not just a very serious crime, the most heinous of crimes, but that crime must then cause deep public revulsion. And that's not theoretical, because the passages talk about crimes having caused deep public revulsion. My lords, if I could then take you to the core bundle and just very briefly look at the first tier tribunal's determination. That begins at page 86 of the bundle.
Yes.
I just wanted to take my lords to paragraph 86, which my lords I think have already seen. First tier tribunal itself dealt with the respondent's case on the basis that it was a combination of the previous offending and the deception.
Yes.
And then at paragraph 119, the judge clearly bears in mind the failure to disclose the previous conviction. 127, and this is where it's important to bear in mind that this is an expert tribunal that deals with these types of cases on a daily basis. I'll come back to the Court of Appeal's guidance on that.
Okay, you're going to come back to it.
Yes.
But if what we're looking at is deep public revulsion, if the challenge was to the finding that the criminal behaviour on its own didn't cause deep crime, does a specialist tribunal have an advantage over us in that? It's not an area of technical specialism.
My lord, I'm sorry, in relation to the nature of the criminal offence? Or,
yes.
I think that what I would say in relation to that, and I'll come back to the authorities, is that the specialist tribunal deals with these types of cases where criminal offending and deception have taken place and relied upon on a day-to-day basis. So it has a good idea of the sort of things that are happening day-to-day in application.
I think my lord's point to you is, if the question is what causes deep public revulsion,
yes,
why is this court not as well placed as the first tier tribunal? I mean, yes, we don't know what goes on in the first tier tribunal every day, as much as them, but are we so out of touch that we aren't as well placed to decide what makes the public deeply revulsed?
my lord, of course, I see force
You
in
don't have
that
to be
point.
nice about it.
No. I see force in the point in that this court is well placed to assess what causes deep public revulsion. But of course, one has to have a most heinous of crime as well. And I think in the immigration context, which is particularly what the appellant's case is about, which is deception on immigration forms, that is where the first tier tribunal and the upper tribunal see a wide range of cases where deception is used, the context of that deception, and whether this really is serious conduct, or is this the sort of conduct that we see on a day-to-day basis for a variety of reasons, which is not really something that is affecting the fundamental interests of society. That's where I would say that the experience of the first tier tribunal and the upper tribunal places them in a better position to judge whether this really is that sort of serious conduct. And that does have some sort of overlap with deep public revulsion. But if it was a case of a serious criminal offence, and whether that type of offending causes deep public revulsion, then I would say that the expertise is of marginal relevance. But this is an immigration context.
Careful how you run this argument, because if deception of the immigration authorities is going on all the time, that may cause the public to be more deeply revulsed than the odd one-off case. I mean, we've heard from the appellant of the concern that one shouldn't in any way seek to belittle or normalise misleading the immigration authorities.
I absolutely accept that, which is why the first tier and the upper tribunal's experience is so important, because deception is, for example, and I come to the facts of this case, this is categorised as a serious deception case. But when one looks at the information that was put into the form, which was inaccurate, and what the effect of that was, and compares it with the sort of information that might be put into a form and the impact of that, one could see that it is on a scale, and I don't mean to minimise any sort of deception or any sort of misrepresentation on a form, but there is a scale of it, and there is an impact of it. You could misrepresent, in this case, for example, by saying that I'm involved in a genuine relationship with my partner, when in fact the relationship is not genuine, or the marriage is not valid. Now that's a far more serious misrepresentation or deception, because it affects the applicant's ability to meet the requirements of the rules, and that can lead to criminal prosecution. But a deception where you don't give comprehensive information, and where that information might be relevant to whether the ECO grants or doesn't grant, but doesn't actually affect the fundamental ability to meet the rules, is of a different nature. I'm not sure at all whether that amounts to a criminal offence. I take my Lord's point that the form says that providing misleading information may lead to prosecution. I've tried to look at the sort of offences that there are available for immigration offences. I can't see that there is an offence made out, or that could be made out, on the facts of this case. But for example, if the deception had been that I'm involved in a relationship that is genuine, when in fact it's a sham marriage, that would lead to the potential for criminal prosecution. Which is why it's important to have a look at the facts of the case and what sort of deception there is on the facts.
And your submission, as I understood it, is that it's a specialist tribunal, and so proper weight needs to be given to all aspects of a specialist tribunal's decision.
And if it was a sham marriage case, then no doubt great weight would have been placed on it by the tribunal, because again, the tribunal is in a position to know the sort of impact that has on effective immigration control. And that's the point that I was making in terms of the relevance of the specialist tribunal assessing the gravity of the deception in this case as it's described. So you can see at 127 that the judge, the FTT judge, accepts, and he describes it as a significant misrepresentation. And so he has that well in mind. At paragraph 130, he accepts that the marriage is perfectly genuine and rejects any suggestion or contention that is sought to gain an immigration advantage arising out of a bogus relationship. He then goes on, I won't take you through each paragraph, but at paragraphs 131 to 136, he sets out the background in terms of the appellant's conduct after his conviction and his conduct whilst he was in prison in the USA. And at 137, he concludes, and I repeat the point made by my Lord through my learned friend submissions, that the last sentence in 137 is an addition to the sentence before, and therefore in the second sentence the judge is saying that there is not established that there is any intentional desire to re-engage in criminal conduct, and then nor is there any evidence that he would be likely to lapse so as to breach the United Kingdom's laws if he considered it expedient to do so, which is a reference in my submission to the fact that he considered it expedient to not disclose his criminal conviction, because that would impact his ability to visit the UK or join his wife in the UK. So that is the background. Of course, the upper tribunal had this decision. So again, as my lords have said,
just out of interest, I don't see anywhere that the first tribunal judge actually answered the question which he posed for himself at paragraph 127. Will I miss something?
Well, just bear with me, my lord.
139.
Well, he answers. I think the language used there in terms of the potential to threaten public order and maintain firm immigration control in the economic interests of society is perhaps not exactly the language that's relevant, because what's required is a serious present sufficient threat to the public interest under EU law. But he answers that question at paragraph 141. So that's his conclusion, that he finds that the respondent in that appeal, the Secretary of State, had not discharged the burden of establishing that the appellant represents a genuine, present, and sufficiently serious threat. And I think
but he doesn't answer it by reference to specifically the immigration context.
He answers it generally without reference to either of those two factors, the previous criminal offending and then the immigration context. But in my submission at 137, he addresses both. He says that there is no risk of reoffending. There's a low risk of reoffending, and he says that there's no evidence that he would likely to lapse into the sort of conduct that he engaged in when he filled out those 3 application forms. And he's building on that in my submission when he concludes at 141 that the Secretary of State had not made out her case.
Yes.
If I could then take my lords to the decision of the upper tribunal. And my lords have already noted at paragraph 14, the judge recognises the scope of the appeal and refers to both issues that were relied upon by the Secretary of State. At paragraph 31 onwards, where the judge sets out the arguments made before him, he refers to both the criminal conviction and at 33 to the immigration history, although when reading into it, the language suggests that the force and the focus of the submissions before him was on the past conviction, and that Ms. Rush had made some reliance upon the appellant's immigration history. And then at 38, the judge sets out the case advanced before him on behalf of the respondent, which clearly was that the Secretary of State had failed to discharge the burden of proof, because the Secretary of State had failed to put in evidence the necessary circumstances to show that the previous criminal conduct was such that it was the most heinous of crimes and had caused public revulsion. We have a complete absence of evidence, and the judge repeatedly refers to that.
39 to 45 is really his analysis relating to her submission, her basic submission on the criminal case in 38.
Yes, my lord, yes. And of course...
and then he goes on to say further submitted.
Yes.
46.
That's right, my lord. And just above that, so between 38 and 45, you have the judge also setting out the evidence that there was before him of the circumstances of the offending in the USA. And there is no appeal from his findings on any of this, and he accepts that evidence. So he accepts on the basis of what was persuasive evidence in my submission, and there's no challenge to his assessment of it, that although the sentence was very high, the offending was not so serious, and that law enforcement officers in the US had expressed their surprise at the length of the sentence that he received. And what you also have in the determination is the judge taking very careful account, as did the STT, of the appellant's conduct after conviction. And that, of course, is rightly relevant to whether there would be deep public revulsion. And my learned friend pointed to the way in which the FTT hearing unfolded, and the appellant not initially accepting that he had done anything wrong, and also not accepting readily that he had used deception or misrepresentation in applying for entry clearance. But it is clear that when one looks at the conduct overall, and the recent conduct is of course coloured by a desire to be with his wife, the conduct in the USA was, in my submission, commendable, and that is certainly the evidence that was before the upper tribunal in terms of the way that law enforcement officers in the USA considered his conduct. Not only did he use his time to rehabilitate, he was found to have been rehabilitated by the FTT, and there's no challenge to that finding. He used the time to educate himself, and he used the time to help law enforcement officers. And he helped them significantly. That was the evidence before the upper tribunal, and that is part of the overall assessment. And that is set out in some detail in the judge's discussion at paragraphs 49 onwards. I won't address the judge's reliance on Gostirani and what he takes from that decision of the Court of Appeal, because that ground is not before the court. But in my submission, the judge's overall assessment of the facts and then applying those facts to the authorities is exemplary. And there are no errors in the way that he has set the law out, and that is something that is accepted by the Secretary of State as well. The focus of the Secretary of State's submissions really is paragraphs 59 and 60, and had those paragraphs been reversed so that 60 was 59 and 59 was 60, we probably wouldn't be here today. In my submission, when one looks at this, I think I'd make the submissions in two ways. First of all, I would say that there's nothing to suggest that the judge didn't take cumulative account of the deception allegation, the deceptive conduct, as the judge refers to it, and the criminal offending. He repeatedly refers to it jointly. That is the approach the first tier tribunal took. And at paragraph 60, the opening of that paragraph, to the extent that Ms. Rushforth relied upon, in my submission, is the sort of language that suggests that you're giving a postscript explaining why you've not spent so much time on the deception issue when concluding that the Secretary of State has failed to discharge her burden. It doesn't suggest in my submission that he's carrying out a separate exercise, having concluded on one point and then going on to conclude on another point. And those introductory words in my submission are important. So when one looks at the determination overall, there's nothing in my submission to suggest that the judge wasn't taking cumulative account of the conduct. But my secondary submission would be that every case is fact-specific, and whereas in some cases cumulative account of conduct would be necessary, in a case such as this, even if the judge separated the two, that would not be an error, because the conduct was so different. On the one hand, you have criminal conduct relating to drugs offences, and on the other hand, you have conduct relating to deception. Now, if there had been a continuation of conduct, so that we have deception offences, deception-related offences, and then a propensity to continue to deceive many years later because one is deceiving on application forms, one can see that it's the same type of conduct. And so one looks to see whether the conduct is sufficiently serious. But this conduct is very different. On the one hand, you have drugs offences. On the other hand, you have misrepresentation in applications for
Why does that matter? Why couldn't someone say, if the facts justified it? Looking at his criminal conduct on its own may not do the job. Looking at his deception on its own may not do the job. But on the facts of the particular case, I'm not saying these facts, but on the facts of the particular case, when you look at both of them, it would cause deep public revulsion to let this person in.
On the facts of the case, my lord, I accept that it
But
potentially...
there might still be different forms of, or different areas of public policy that are being impacted. So you accept that in theory that could happen on particular facts?
On the particular facts, my lord.
You're
It
just
all
saying that
depends
on the
the
particular facts here,
Yes.
it's justifiable to treat them separately if he did.
My lord, yes.
Which is
That's
possible.
my submission. That
Okay.
on the facts here, when one thinks about the conviction and the sort of antiquity of it now, it's 1994 that he was convicted. He spent 26 years in prison. And the deception, I think, relates to 2020.
Because you could have two things, three things. One, they're so separate they bear no relation to each other
Yes.
and should be looked at completely separately. Two, they may have a cumulative effect. A plus B equals A plus B.
Yes.
Or they could have a synergistic effect on the attitude of public revulsion. A plus B equals 5AB.
My lord, yes. And again, it all depends on the facts. What sort
Yeah.
of conduct was there, and what sort of conduct is this person engaging in now? And they could be unrelated,
Okay.
but still.
So it's a very narrow, your second point is a very narrow submission. It's just on these
based
facts.
on these facts.
Okay.
Did the judge commit an error? And one also has to look at the test very carefully, because the test always looks at, and that might be because that is the way that the cases have unfolded. It's always one offence, and whether that is the most serious of conduct, and whether that has caused deep public revulsion. So one has to be careful before generally assuming that a combination of conduct could meet this test, because it's a very specific test. And so, Judge, my lords, I would say that either way, there is no error of law. And the other thing
Yes.
I would say is that even if there has been a separation, and there shouldn't have been a separation, the third point is that error of law material? And my submission would be that on the facts of this case, it simply gets nowhere near, in the words of a Tribunal Judge Grubb, the sort of offending and conduct that is required in order to meet the Bouchereau exception. That's where one goes back to the language used in all of the cases describing the sort of conduct, because it is an exception. And it has to cause deep public revulsion. It has to be the most heinous of crimes, very exceptional cases, extreme facts. There simply isn't that case. And if I could just spend a bit of time on the deception issue, because it is important, and I know what my learned friend said, and it was said in the skeleton in support of the application for permission to appeal, that the deception issue is an issue that troubles the Secretary of State. And what is said by this court might be relevant in other cases if one does embark upon some sort of assessment of whether deception could be relevant and the circumstances at which it could be relevant. The first point I would make is that the court ought to be cautious before making those sorts of statements when it is not strictly necessary to determine this appeal. The second point is that as far as deception is concerned, there is nothing that suggests that this sort of deception even amounts to a criminal offence. And all of the cases, Bouchereau itself and all the subsequent cases, are looking at conduct that is criminal. And that is a given, that the conduct is criminal. And it's in the context of criminal conduct that the courts have said that it has to be the most heinous of crimes in order to get into the Bouchereau exception. So we're not even looking at criminal conduct here. There's been no attempt by the Secretary of State to prosecute, and no offence identified that could be relevant to the conduct in this appeal. It is also relevant to look at the way that deception in an immigration application is dealt with under EU law and dealt with under the rules, because that gives one an idea of the sort of gravity that deception carries with it in terms of public revulsion and the Secretary of State's own policy. Under EU law, deception in an application is not a ground in and of itself for refusing the application. Under domestic immigration law, it is. So one would be almost by the back door introducing deception as something that's potentially relevant to removing an individual from the UK who enjoys a right of residence under EU law, when one could not deprive him of that right by virtue of the deception on its own.
What's the provision in EU law?
There is no provision for it, my lord. So there's
No, okay, sorry, it's the wrong way around of what. How do we understand that to be a principle of EU law?
I wouldn't say
It's absent from the regulations.
My lord, yes, the absence from the directive and the regulations, so that the only way in which one can interfere with EU law rights is by virtue of the public policy, public health and public security exception.
Right, but there's no, so it's absent from the directive, but there's no CJEU decision that says deception is not a ground in and of itself for refusing.
No. It's simply not in the relevant statutory instruments, whether that's the directive, the regulations previously, or the 2016 regulations.
Although it is, you say, under UK.
It is. So under the immigration rules, deception is a ground for refusal. But in the appellant's circumstances, where he has applied to join his spouse, even under the UK's immigration rules, deception, or past deception, would not be a basis for refusing an application to join your spouse in the UK. So generally under the rules, if you've used deception in a past immigration application, there's a 10-year ban on entry clearance. So if you're a visitor, for example, which were his first two applications, he used deception in his first two visit visa applications, that finding would result in a 10-year ban, preventing him from coming into the UK because of the past deception. But that would not be a bar to him joining his spouse, and that is a specific exclusion in the rules. It's not something, obviously, that's arisen on the papers. I can certainly provide the references after hearing if it is necessary or desirable.
Thank you.
No, yes. So under domestic rules, the deception is not considered so serious that it would prevent him from joining his spouse, which is exactly what his application for an USS Family Permit was for, and which is what would result if the public...
and we seem to be going slightly off track, because your submission is not that deception can form, as a matter of general principle, a relevant factor, and you're just saying that in this case, the judge properly took it into account.
Yes, it was only, yes.
And I don't think we're going to be making great pronouncements.
We're not.
Grateful for that indication, my lord.
Other than by accident.
Yes, and I think, again, that was leading to my submission, which I think I've already made, that the judge was right to say that there was absolutely nothing remotely close to the Bouchereau exception in those three failures to declare his previous criminal offending. And again, I contrasted it previously with the sort of deception where one claims to be in a relationship that one is not genuinely in. That is a totally different category of deception.
Yes.
What you have on the facts here.
Because that would take you out of the provision altogether.
My lords, yes. Then I think it just remains for me to refer, my lords, to the authorities with respect to paying respect to the determination of an expert tribunal. I've referred to one, A.H. Sudan, in my skeleton. That judgment is at page 55 of the authorities bundle. And it's paragraph 30.
30.
My lords, yes, that's 68, page 68 of the bundle.
Yes.
And then a more recent decision of the Court of Appeal in KM and Secretary of State, and and the relevant paragraph is at page 166 of the authorities bundle. And
166. Paragraph?
Paragraph 77, which very helpfully lists the well-established principles.
Yes.
And again, restraint in terms of readily assuming that a tribunal has misdirected itself. And I would say that that applies with even more force here, when the judge has, and the Secretary of State accepts, set out the applicable law entirely correctly. The submission is that he did that, but made an error in applying the law.
Yes.
And in my submission, there simply isn't anything, nothing remotely sufficient in the determination to make good the submission that despite setting out the law correctly, he misapplied it.
Do you want to say anything about your respondent's notice?
That, my lord, is I don't think that is disputed. I had a short conversation with my friend this morning that if there is an error of law, what that amounts to is that it needs to go back.
Right.
There's been no exercise in terms of assessing proportionality. But I think we're in agreement that if there is an error of law found by the court, that the court ought not to make the decision for itself, it ought to go back. But,
Yes, my lord.
Okay. So
It's
that
a
there's...
material error of law.
yeah, of course,
Material.
material error of law.
Do you have any questions? Thank you very much.
Thank you,
indeed.
my lords. Of course, there is a short skeleton. I'd ask my lords to refer to that. Those submissions build on the short skeleton. There's nothing new
Certainly.
that I've said. It's in the core bundle.
I would not describe it as short.
Okay.
I would describe it as comprehensive.
I'm grateful, my lord. It's pages 24 to 30.
Yes. Thank you.
I'm grateful.
Yes.
My lords, I'm conscious of the time, although I don't have much. to
No,
say
I think...
reply.
well,
Just dealing with the specific points, if I may, it'll only take a couple of minutes.
fine.
The first is that there certainly doesn't seem to be much clarity as to whether lying on an application form is specifically a criminal offence or not. My learned friend hasn't found one, we haven't found one. However, I should say that there is a criminal immigration offence of deception. And given that it potentially might be deception, my earlier submission that it clearly isn't a criminal offence probably shouldn't be stated quite so
Right.
unequivocally.
Okay.
It may be, but there isn't a specific one.
Deception is,
Yes.
but we've used the word deception, everybody, in the course of their submissions.
Yes.
Maybe not as a matter of legal definition, but as a matter of... So just... Anyway, okay.
Yes. In any event, it's not a major point. Then my Lord Justice Stuart-Smith asked me as to whether the two elements of conduct here were heinous crimes. I expressed my own personal view. I'm afraid I'm unable to give you an institutional view. I'm told that I don't have instructions.
Right,
Whether
okay.
Then finally, as to the relevance of deception, I would simply remind the court, of course, that Schedule 1 of the regulations, which we looked at in the fundamental interests, at paragraph 7a, it is expressly concerned with preventing immigration abuse.
Yes.
So, in my submission, whether or not it's a crime, in applying these regulations,
It's irrelevant. It's made expressly.
it's
irrelevant.
expressly relevant.
Yes.
That is one of the fundamental interests that must be protected. And my Lord Justice Stuart-Smith raised the possibility of very different sorts of conduct together might tip the balance and meet the exception. I would say that that must be the case. And that in this case, one of those tipping points can be immigration deception, criminal or not, because it's a fundamental interest that the regulations seek to protect. My Lords, unless there's anything from the court, I have nothing further.
Okay, at the risk of irritating people at 1 minute to 1, one thing that just occurred when I was listening to Mr. Chatterjee in relation when he was taking us through the first tier tribunal. Let me just put this proposition to you. In paragraph 127 of the first tier tribunal, bottom of page 100, this first tier tribunal judge posed himself a question. I asked where he'd found the answer to that, or where he'd answered the of these suggestions was that he answered it in paragraph 137 when he said that there's just no evidence to be likely to lapse so as to breach the United Kingdom laws if he considered it expedient to do so. And that was what the upper tribunal judge, Judge Grubb, thought in the paragraph 35. That was his finding in paragraph 35 of the upper tribunal's decision.
Yes, was
with,
it?
with me so far?
Yes, my lord.
Right. Is the upper tribunal's point that that's what the first tier tribunal must have been speaking about, consistent with the following point, that having posed himself the question in paragraph 127, unless you read 137 the way that the upper tribunal judge did, he never actually answered the question he posed himself. So, in fact, isn't it a fair reading of the first tier tribunal's decision that having posed himself the question, he answered it in 137 because he didn't answer anywhere else, and therefore paragraph 35 of the upper tribunal's decision was correct on that point? Because otherwise, he just never answered. The first tier tribunal never answered the question. That's just the point I put to you. You can disagree with it. Or
Yes, my lord. I see the force of the point. So paragraph, I think it's paragraph 34 of the upper tribunal makes the finding that there was a risk of relapse or reoffending in respect, no propensity to commit further immigration fraud. And as my lord points out, first tier tribunal judge Moylan poses himself the question, and I see the force of.
It was 35. It was the first sentence of 35. He says. He picks up the end of paragraph 137, those words, in 34, and then in 35 he says, that in my view can only be a reference to the additional fundamental interests of society relied upon before Judge Moylan, namely that related to immigration fraud or deception. So he takes the view that, the answer to the question that the Judge Moylan posed himself in 127 was to be found in the last sentence of 137. And that's his finding. I mean, I'm just putting to you that it is a reading of how he got that.
My lord, I have to accept that is a reading. I think my only submission was in the context of whether deception is going to be committed in the future. If it's committed on the day in front of you, that's quite a strong indicator, and one would need strong words to indicate that despite lying in his evidence, there's still a finding that he wouldn't lie in the future.
Except the point is he's lied for a particular purpose.
Yes.
Which has been identified, which isn't going to be repeated.
Well, my lord, that purpose might well be repeated because his family permit it expires. I think it would have expired in 2021. So there would have come a point where his immigration status, he would need to make further applications.
But he may decide that the Secretary of State is sensitised by the time he comes to make such an application.
I think no.
Yes, my client is perhaps better at evading the question than I am, and says that cumulatively, the deception plus the crime is a heinous crime. Those are my instructions.
Thank you. Well, cumulatively, they bring you within the exception.
That has to be your case.
Yes, that has to be.
Yeah. Thank you very much indeed. Thank you. Any questions? No. Thank you both very much for your respective submissions. We will be reserving, of course, our judgments. They will be distributed in due course in the usual way for you to correct any typographical errors. And as you will know, set out at the top, you can use the judgment only for very limited purposes. And we would hope once you've got judgment, we'll be able to agree ancillary matters, including providing a draft order. But if there are any outstanding issues, we will deal with them on paper. So thank you very much.
Great.
Thank you for finishing in the morning.
Court rise, if able.
Still.